All right, well, the case background. The case starts with the law firm of a local company coming to us and telling us that they needed a forensic investigation done for their client. And the backstory is that two employees that were working for the company, they just one day up and left the company, and the grapevine said that they went to a competitor company who was new in town that was doing the same exact business as this company was doing. The concern for the plaintiff company was that the two people who left, one was one of their main sales associates, and the other one was a marketing associate. So these were two very key people to this small company. And when I say small, there was about 110 employees there. So the plaintiff company became concerned when they noticed that they had lost a few customers. And they realized that when one of their salespeople had called a customer, trying to figure out why the customer hadn't been placing orders. And the customer says, well, I'm now doing business with so-and-so who used to work for you, and now she works at this other company. So this immediately made the plaintiff company very alarmed. They thought that they might have some trouble because they held on to many Department of Defense contracts, working directly with the United States government and other vendors that worked with the government. So they came to us through the law firm and they said, please analyze these two computers. We have no idea what we're looking for, but something may be amiss. These people left. We know that they're working with our clients and customers, so tell us what you can find out. And it didn't take us very long to find out that these two people were speaking with the competitor company about 2 months prior to leaving the plaintiff company. And we also found very quickly that they took proprietary information on their way out the door. And you see that I have starred there, most common type of civil forensic investigation. Now, Peter and I get involved with many different types of civil cases. Some of the cases can go criminal. This one, as you're going to find out, ended up going criminal also. But 9.9 times out of 10, our cases involve some sort of theft or proprietary information. You know, we get involved with companies that have policy violations, or maybe sexual harassment lawsuits, or unlawful termination lawsuits, or even some divorce cases. But the number one case that we see is the theft of proprietary information, and it usually involves somebody who's in middle or upper management who is taking something out the door and they're going to use it for their own benefit at their new startup company or at the new employer.
I think an important thing also that I want to know or just point out is that this never would have occurred, and we try to go out there and actually educate a lot of the attorneys that we work with that there is something that can be done in this situation. And once they find out, yes, save that computer, make sure that the IT person at the local organization is not poking around and trying to actually see what was done. Calling a computer forensic expert first is the right move most of the time. So I think that's one of the things, again, you have a forward-thinking attorney or someone that we've spoken with or worked with in the past, and they're able to effectively help their client by making sure they're giving us a call, seeing if we can actually assist in the process.
Yeah, I wish I had a nickel for every time that I got a call from a law firm or a corporation who says that, well, IT has already looked at this computer and this is what they think they found. And I tell them right away that, what you've just told me is tantamount to going to a crime scene and picking up the bloody knife and holding it up and saying, yeah, there's a bloody knife here, I better put it back down. So essentially they're stepping all over the evidence.
And I see John Williams has a question that says, are there best practices on how long to hold computers of exiting employees, particularly in cases of sudden departure? That's a question that we're often asked. We're not lawyers, but certainly, I've often talked to attorneys and said, well, what did the person do? What level of access did they have to trade secrets? What level of access did they actually have to things that you wouldn't want other people or other organizations to have? And probably the answer is, well, as most employees do, they probably have the keys to the kingdom in some sense. So I don't know if there's any real answer of how long to do it. I do know, as probably many of you on the call here know, that it doesn't cost too much to actually preserve that evidence forensically, put it on a shelf. Hard drives are not as expensive as they were 10, 15 years ago, where they need to be repurposed every time. So certainly I think that's going to depend, best practice would speak, what kind of industry are you in? How often do you have turnover within the organization? Certainly, is it a high-level person that might want to or could have ability to access information you wouldn't want to leak out? So the answer is my ultimate consulting answer, which is it depends.
And Nick also has a question about whether or not we hold the whole computer, or we recommend holding the whole computer, or recommending just the hard drive. And someone else had typed here that the computers take up too much space, and that's absolutely true. If you do a forensic image of the computer, and you do it properly, and you get the BIOS date and time, you're all set, I think, with just holding on to the hard drive. And then you can put a new hard drive in or repurpose the computer.
And also, yeah, Jonathan Joe said not to keep too much or over-preserve or overkeep, as he stated, and that potentially does open yourself up to liabilities with eDiscovery. It's certainly an issue that, and that's again where an organization is going to have part of their data or document retention, or what I like to call data destruction policy. How long do you actually keep these things, these documents electronically? How long do you keep email archives, email stores? That's a huge, huge issue for organizations. Just trying to get a handle on all the information they potentially have out there is a tremendous effort, and as you know, a complete cottage industry for eDiscovery, and not just computer forensics. So we're going to move on to the next slide, but keep asking questions if you have them. So one of the things that we typically do when we go on site is we'll bring out some logic cubes or other equipment to actually forensically image hard drives. We like to find out beforehand what we're going to be encountering, and 8 times out of 10, it's not what they said. They're like, oh, we've got 2 laptops. Well, then the laptops have, zip drives, and you need special connectors, or they're Mac Airbooks, and they're this, and there's now 10 computers instead of 2. So that is typically what happens. So we try to be prepared as best we can when we're out in the field. And that's, as you probably all well know, that's one of the tenets of what we try to do, is be prepared like the Boy Scouts. Well, then we took back the actual drives to the lab after we were done procuring the evidence and verifying it on site, and creating the chain of custody documentation, the documentation around actually what was collected. Typically, we will, if the computer exists, track the BIOS information, take pictures of the computer, the serial number on the hard drive, the date of the manufacturer, anything that we believe might be useful at some other point, because we're not usually taking possession of the actual original evidence. So we're then going to come into a situation where we have best evidence of what we're actually taking or making an image of. When we get it back to the actual lab, we're using a number of different tools. The main 2 tools that we're using are FTK and NCase. We have a number of scripts that will run, some that we've created custom within NCase, and some of the other just basics, data carving that is built into the FTK software, and we will index all that data so we can search it, making sure we're obviously indexing all the unallocated space and all the good stuff that you're potentially going to get from data carving. In this particular case, as in many, we get an initial list of terms or things to look for. So the back and forth of the attorney will say, hey, this guy did that, and he's this type of a computer user. And that's one of the things I always like about computer forensics, is it's not just about computers. It is actually getting to know the person that you're investigating. Are they 30? Are they 70? Are they a computer programmer? Are they a landscape? What is their job? What's their profession? How computer savvy are they? Are you going to anticipate any kind of tricks or hidden data that may come up within the drive, encrypted files, etc., etc.? So that's obviously, I think, a very helpful thing, which kind of goes outside in more of a traditional law enforcement, and John can back me up on this, more of a traditional law enforcement technique of know your suspect, or know the person that you're actually investigating, and that can certainly help.
Yeah, I always tell the lawyers that I'm working with, please tell me everything you know about the case, and that way I can be the most effective and efficient for you. Because in the civil world, time is money, and everyone is billing by the hour, as opposed to the criminal world, where sometimes they have a luxury of working on a case for many weeks, if not months. Not always, obviously, but in the civil world, a law firm may approve 10 hours, 15 hours, and that's it, and you've got to get the job done. So you have to come up with a very specific hit list with a law firm, and the only way you can do that is to really know all the ins and outs of their case and what they're trying to accomplish.
And then also trying to, when they say, I want all the hits, I mean, they're typically, a lot of attorneys are used to dealing in the eDiscovery world, so it is an education process where you have to say, well, there's a lot of hits in unallocated space. You've got to explain what that is very carefully and how it's just not possible to carve out everything. And really, what is the crux or what is the main area that you're concerned with? So sort of working back and forth, the give and take, it's an iterative process of going forward with trying to identify those things or items or pieces of evidence that are going to be the most useful. In this case in particular, we did find a number of items in unallocated space, so we undertook some data carving efforts where we were able to identify some emails that were actually Yahoo mail messages, and we were able to provide those to the attorney, and they were very helpful. So I'll just start with a question here. Are there any dedicated drive duplicators that can decrypt BitLocker drives on the fly? I do not know. I have not heard of any, so I don't think so. I don't know if that's. I don't know. That's my deposition answer. I don't know. I'm not sure, but it's a great question. I know that when we have actually many times in the past tried to image encrypted drives that are, basically tied to the motherboard of the laptops, the devices that we use to try to actually image them, it fails out immediately, and we have to go to an alternative method of imaging that drive, which would be putting it back in the laptop and then using a disk to boot up and putting in an external USB device where we can then output that image to that drive. So that certainly has happened to me in the past, and I don't know the answer to that question, but it's a good one.
All right, back to the case study. So in this particular case, the corporate email was not the source of the evidence. And I see this all the time in these cases where there's theft of proprietary information. Some people are pretty smart and they don't use the corporate email servers. Others aren't so smart and they do it all the time. But I usually see that data is going out via USB or CD or DVD burning or commonly web-based email. And in this particular case, there was a few web-based emails that were found in the active internet history, and also fragments that we found in unallocated clusters. And within the live emails that we saw, for the 2-month period before these people left the company, they were actually actively negotiating their salaries with the new employer. They were talking about bonuses, and they also went on a couple of trips to New York City that were sold as meeting trips and entertainment trips. And it's just a way for this Chinese-based company to get these key people away from their original company and to come working for them. But the smoking gun in this case was these two lists. There was a company price list and a company customer list. We're only talking about 3.1 megabytes of data. And these two files were what made this case. And those happen to be attachments in web-based email.
And that's, from the attorneys that I have spoken with, that's the big thing in these cases, in any kind of trade secret misappropriation, or if there's a non-compete or any kind of theft of really intellectual property from an organization, they want evidence that something has been shared, something has been taken, because otherwise there's not a lot to go after, and the courts may not let you get access to the other corporate computers that are on the other side. We have some questions here. First of all, it's going to be David Lebnick. I've never used log2 timeline. No, but I will look at that. Oh, you have?
A couple of times.
Oh, okay. Well, I have not. Go ahead. What is it?
It will just give you a timeline of what's going on the computer.
Oh, yeah. Great. It's good.
I like to do things the old-fashioned way, where I'm actually looking for particular items and putting 2 and 2 together.
All right, live emails, does that mean you are capturing keystrokes? No, I think by live emails, John means, or I know what he means, is that we're actually to identify undeleted emails, so emails that were not yet deleted, so they were in the internet cache at that point. So they weren't necessarily in an email box like a PST or something else, but they were actually non-deleted emails that were easily retrievable without using data carving techniques. And we were not using a network. This is all dead forensics, and by that I mean this is not anything that we were monitoring while these machines were live, and we do not do any type of live forensics here. All we do is sort of the post-mortem, looking at like the dead body, so to speak, in a criminal investigation. So we're not actively looking at things such as that. This was in New York State.
We'll get to that.
State, yeah, we're going to get to that to the next slide with a couple of those questions about the company's emails. And how often do you see data go out via rogue wireless AP?
We don't do that type of
Yeah, we don't do that type of work.
Dead forensics.
Dead forensics, right.
All right, in this case, the law firm was able to successfully argue to obtain the home computers and the computers being used by these two people at the competitor's company headquarters. This is kind of amazing that they were able to make that argument to get the home computers, but they did so because of the web-based email. Everyone was calling it home email, their personal email, home email. Those are the terms they kept hearing. And the court said, you know what, if it's their home email, it must be we have to give them their home computers for analysis. And that's what we did. So the defendants ended up being under court order to provide their home computers, all of them, and their computers that they used at the new facility or the new company they were working for. And of course, we found evidence in all those computers, and it was actually a really boon for us because it made this case come full circle. There was electronic copies now of the things that they had at the company list and the customer list. Although they deleted them prior to us coming and doing the forensic imaging, we were able to also locate those in unallocated clusters, restore those, and present them as pieces of evidence.
Yeah, Bert has a question. How would you clarify the industry accepted difference between eDiscovery and forensics? And I don't know if there's any industry accepted difference between it. I can give you my opinion of it. So someone else's may differ, but I often describe forensics as a subset of the eDiscovery process because it is still part of discovery. That's one part of it because it's going to be involved in civil litigation. So it's more of a deeper dive discovery. Whereas in eDiscovery, you're dealing with massive amounts, terabytes of data potentially, of large amounts of email, and you're able to apply keywords, other calling techniques, deduping, and really the intent is to provide the bulk of data, potentially relevant documents, or a subset of the corpus to a large review team, or even a small review team if it's a small number of documents. But some of the cases we get involved with have millions of documents, and those are being pushed to a tool like relativity or concordance or summation, and then they are being used to or being reviewed by attorneys. With the forensics, it's usually more of a single person or a small team that's working on a small number of computers, or a person's computer, or 5 or 6 computers that were used by a group. So I'm not saying necessarily it's only one person or one computer, but it's certainly typically a smaller subset where you're actually going in and trying to recover deleted files, something that's typically not a factor in eDiscovery cases.
Yeah, I can simplify it, and I like to say that eDiscovery is basically looking at a large amount of data, and you're looking at it basically with using keyword searching and date filtering for the most part. The forensic piece, though, I liken it to actually discovering and looking at user behaviors. Now, you can use the same search terms, same methodology in forensics that you're using for eDiscovery when it comes to searching, but the forensics, I think, takes it to a whole other level, and you're actually identifying what the person has done on this computer prior to you getting it. And, every computer tells a story. Every computer has a personality. They often mimic the personality of the person who's using that computer. So, with the forensics, you're going to be able to get into the registry. You're going to be able to see what kind of tools they might have run to hide evidence, to eliminate evidence, to look at the different log files of other activity that's gone on. With eDiscovery, you're not going to get any of that. You're just looking at live active data.
But there's also, and I know John's working on a case right now for a large corporation where we're on the other side, and it's a big eDiscovery case, and there has been some evidence that one of the key engineers has actually deleted a lot of information that should have been preserved, and we're now in a forensic mode where this large eDiscovery case is now turned into still the eDiscovery case, but now there's this smaller subset of forensics that we need to talk about or undertake in this one particular instance with this one particular engineer.
Yeah, I'm going to go in and I'm going to forensically image the computers that this person had access to, and we're going to actually try to discover that their behavior leading up to and including the deletion of the critical data. Let's go.
All right, so the next slide here is...
So obviously this was a civil case, and the case concluded as a civil case. And what had happened was in settlement, the owners of the Chinese
Okay.
All right. I don't know what happened there.
Michael, can you give us a thumbs up that you can see us and hear us? Beautiful. All right, sorry about that.
You can see us? I mean, I can't see start my webcam. Whoop. All right, we're back. I don't know what happened.
All right, it doesn't matter. As I was saying, here, the conclusion of this case on the civil side was there was an $80,000 cash payment to the plaintiffs. All of the products that the defendants had in their warehouse on the settlement day was given to the plaintiffs. All of the computers that they were using were wiped and turned over to the plaintiffs. And finally, the defendant's company was completely shut down. So that's the civil side of things.
Yeah, I think that's a really good point. Like, look at these two individuals who basically were just out to make more money and go forward, and the other company was trying to entice them to come over, and they ended up getting shut down, the whole company. So I think it's a huge thing. And again, John and I talk about this case, and just from what we were able to find and identify from that one phone call, and just from, hey, this guy's taking customers from us, it opened up this huge other just area of just this whole Pandora's box of what was going on. The lawyer was very happy.
In this case, though, it was very interesting because there was also a criminal side. And when it comes to civil investigations, I would say 9.99 times out of 10, they never go criminal. Even though a criminal act may have occurred, the companies don't like to draw themselves to law enforcement. They don't want to see their name in the paper or hear it on the radio or the evening news. So they try to keep things on the civil side and never go criminal. But in this case, the victim company was extremely upset, and they went to the United States Attorney's Office to see if they would prosecute on a federal level because of the fact that there were so many Department of Defense contracts involved with this company possessing. So I personally went to the U.S. Attorney's Office in a neighboring city and met with the Department of Defense, the U.S. Attorney, the FBI, the New York State Police, told them about the case. We showed them what the evidence was, and ultimately they were considering the federal charges on these two people for taking the proprietary information. But at the end of the day, they were able to negotiate a deal, and these two people ended up pleading guilty to state charges. And the charge was unlawful duplication of computer-related material in the first degree. And that is from the New York State Penal Law. So we had a question earlier about what state this is in. It's in New York State. So that is an E-felony, which is the lowest level of all felonies. And these two people ended up receiving fines and 5 years probation.
And, one of the questions Steve M. just asked, and I'll kind of answer on the next slide, but we'll go back to John Williams. On this case, how long did it take from when we first got the case until settlement? It was a long time, right?
It was probably about 11 months.
Yeah, so a little less than a year.
Yeah, but as civil cases go, I'm working on cases now that I had in 2009. They're still in litigation. So that's the difference, too, between the civil and the criminal. The criminal can usually get settled in 6 months to a year, maybe a year and a half. The civil cases will drag on for many, many years.
And I've had cases I've worked on that are from 2006 and even before that. So, that's the civil process can go on and on depending on the actual action or what's happening. I worked on, starting in 2003, I worked for the New York City Law Department, and we were in charge of collecting all the evidence from the New York City agencies with regards to the response to the World Trade Center terrorist attack. And that case is still going on from then, and it was, obviously they were preserving in anticipation of the many claims that are now being filed in terms of the cleanup and all the bad things that happen to people from the pollutants in the air.
All right, 3 questions there. Were there any charges to the defecting employees? Yes, there were. Steve says, evidence handling. Do you approach civil cases and criminal cases differently?
No.
No, we do not. We approach every single case that we're involved with law enforcement standards, from the data collection in the field to the chain of custody to the evidence being secured here at our facility. Every step of the way that the evidence is monitored and it's logged. So we test and we validate all of our tools before we take them out in the field. That's something that law enforcement does. So these logic cubes that we're using, we make sure that we have vetted them before we ever use them, and it's an ongoing process. We have test data. We know the hash values. We'll hash that data, and if we get the right results with that device, then we take that device out in the field.
And you never, this case, very rarely do cases go from civil to criminal in the items that we work on. So this is a very rare one. But you never know. It's going to happen. You've got to treat it. If you don't walk into the situation thinking that this may be at that level or proceed to that level or get escalated, then you're only doing yourself, your organization, and the lawyers that you're working for, and the end client, you're just doing them a disservice. So it's really important that you do treat every single project the same way in terms of how you handle it.
Yeah, and I'm glad you mentioned that. I'm working a case right now. It's about 6 months old, and it's proprietary. Theft of proprietary information has to do with a 4 gigabyte thumb drive that has about 500 megabytes of data on it that was taken by a key person in this one organization and went to a direct competitor, national companies. The victim company is extremely upset about this, and they are suing for $25 million, all over a little bit of data on one thumb drive. So when this case first came to me, the lawyers call up and says, well, we just have a thumb drive we want you to look at. We want you to give us the the MAC times of all the files, and we just want to see what it's all about. And before you know it, now we're looking at this person's old work computer, new work computer, all their home computers, and the case is really blooming into something very big. And the victim company is not going to settle for anything less than the $25 million.
And Don, you said the feds can still come after them, correct? I probably part of their plea bargain was that they probably can't, but John, do you know?
They won't. No, technically, if it wasn't part of the plea bargain, they won't. Technically, they could, but they won't. It's very rare that you'll have state charges and federal charges. Although legally it's possible, they won't do it. Usually a county, in New York State, it was a county district attorney and a local assistant U.S. attorney would have had conversation about the case, and they would decide who was actually going to handle it.
And criminal, as some of you may know, is based on statute. So if there's no corresponding federal statute, then they probably felt that there was that New York statute that they could get these guys on the charges, and that's why they went after that. So maybe there was another, not a corresponding federal statute they felt, or some kind of computer crime that they felt they might have a problem prosecuting, so they may have went that route.
In this case, that we were able to determine that it appeared that no Department of Defense information or contracts were compromised in any way. So that also led the feds to not want to pursue the case. Usually if the feds are going to get involved, it has to be a very large case. Oftentimes a lot of money is involved and a lot of people.
I don't know what an Anton Pillar is. Is that a kind of beer or something? Or if it is, I'll try one. No, I don't know what the Anton Pillar is.
Yeah. We don't have anything like that in the U.S. At least not in New York.
Well, you don't know what it is, but...
Well, listen, I was a police officer for 25 years.
You know what it is?
Well,
Okay.
I'm not a lawyer, I know criminal law.
All right, great.